All right, so I'm Megan Wanlass, and I'll be giving the presentation for adjudication. So the basic question is, what is adjudication? Adjudication, in its broadest sense, is just an action in the state district court. But more specifically, a general stream adjudication is a bit different. It joins all water users, including state and federal agencies and the state engineer, as parties in the litigation. This is really important to join all parties in a litigation in a drainage so it doesn't create multiple decrees that might contradict one another or leave out water users. This is governed by Utah State Code, Title 73, Chapter 4. And as you can see on this map, these river drainage, every major river drainage in the state of Utah is currently or has been under a general stream adjudication order. Some of these adjudications were petitioned by water users to the state engineer, and others have been court ordered by expanding the scope of an existing dispute among parties. So with these drainages, these can get really large, and water development is growing pretty quickly throughout the state, which means more water rights. So the main river drainages are often split into smaller areas, if you can see that on the map, and these are known as subdivisions or divisions. And these just make it easier for staff to work through these areas relatively quickly. It still takes quite a long time. So why do we conduct general adjudications? Well, it depends. Originally, it's to bring all claims onto the permanent record. So originally, this would be pre-statutory claims. These are claims that were initiated prior to the adoption of water right law. So these water rights might not even have a record with us. These might have been some family who drilled a well and never brought it to the attention of the state engineer. And so part of these adjudications is to capture those that we were unaware of until the adjudication. Adjudications were also conducted to bring Federal Reserve rights onto the record. So as a result of the 1908 Supreme Court decision, which is Winters v. United States, the court ruled that by the creation of an Indian reservation known as Fort Belknap, there was an implied water right for the amount of water that the reservation needs to be self-sufficient. Today, Federal Reserve water rights can be asserted on most lands that are owned by the federal government. And reserve rights are, for the most part, immune to state laws. Therefore, they're not subject to divergent and beneficial use requirements and cannot be lost through non-use. They're also limited to a primary purpose or minimal needs of the reservation or respective federal agency. So in addition, because of this, Federal Reserve rights are non-transferable and they can only exist on land that's owned by the federal government. And moving on, the McCarran Amendment, which was introduced in 1952 by Senator McCarran of Nevada, waives U.S. sovereignty immunity with respect to just water rights. So this allows states to pursue quantifications of Federal Reserve water rights and determine federal water rights in our state courts. Other reasons we would conduct general adjudications is, as I mentioned before, to prevent a multiplicity of suits. So two individuals arguing over their water rights in a certain stream drainage would need to bring in all of the water users for that stream to really properly determine what their rights to that water are. Another reason is to remove or reduce rights that have been wholly or partially forfeited through non-use. So this could be defining supplemental relationships. This could be removing rights that were once for 25 acres and are now just for a single home irrigation. And lastly, to obtain a final comprehensive decree on all water rights within the drainage. So currently, our adjudication efforts We're focusing on areas that are experiencing the greatest development. And we're able to move through these areas more quickly due to some revised statute. SB 75 is essentially the publication of a list of unclaimed rights, and we'll talk more about this later. But according to this statute, if a water user fails to file a claim on their water right number gets placed on a list of unclaimed rights and gets submitted to the court. And as I said, we'll talk more about this later. SB 61 and HB 355 deal with the summons and how we deal with those, and I will also talk about that later. So if you can see on this map, the gray areas are where a proposed determination has already been published. So these were started in the 1940s, I believe, and as you notice, these are much, much larger than the newer areas that we have. And that's just because there's more water rights and it's easier to break these up into these smaller divisions. So we're actually finishing up through this Salt Lake Valley area. And as you can see, there's blue, which means the PD book has been published, and the solid blue is decreed. And the majority of our staff are actually in the Utah Wasatch counties. So this would be Lehigh, American Fork, and we have Daniels Creek that just opened in January. So that's what we're working through. And these are all in the Utah Lake Jordan River drainage. So now I'm going to talk a little bit more about the whole process of adjudication. And this next slide is just going to show the main elements of this process from beginning to end. Before I go through these processes, I'm just going to address that HB 355 that I talked about earlier. So HB 355 essentially moved this final summons up towards after the LUR. And we'll talk about that later. So list of unclaimed rights, or LUR. And this is just to wrap up the final claims process and to get a decree out of these list of unclaimed rights. And we'll talk about this. So now to start at the beginning. First, the adjudication process is initiated in two ways. This can be water users may petition the state engineer to file an action in the district court to initiate this adjudication, or a suit involving an action involving several water rights may be converted into a general water rights adjudication. Involving several water rights can just be converted into one larger adjudication. So this has already happened in all 15 of the major drainages in the state of Utah. Next, for each area, division, subdivision, the state engineer will publish a notice in the newspaper, designated by the court once a week for 2 consecutive weeks. This notice will have the name of the action, it will have the court's location, and the name of the water source that is involved. And then there will be a summons sent out to potential claimants of record by mail. So these are property owners in the area, and these are also people on our records that own a water right. This summons is also published in a newspaper designated by the court for 1 week, once a week for 5 weeks. And then the state engineer will hold a public meeting in the adjudication area, and this is just to inform the water right owners and claimants about the process. After this first public meeting, the state engineer will send a notice to claimants to file a statement of claim, or a water user's claim, and we'll talk more about this. Claimants have 90 days from the date of the notice to file with the state engineer or their respective district court. Claimants may request a 30-day extension, but they must request it with the state engineer prior to the conclusion of the 90 days. Claimants who fail to file a claim within the time frame or the authorized extension will risk being prevented from asserting their claim in the future or having any unclaimed right deemed abandoned by the court. So as I mentioned, after the conclusion of the 90-day filing period and the 30-day extension, there will then be a list of unclaimed rights, and it will be published and filed with the court to document water rights that exist on our records with the state of Utah, but there was no claim filed. So this is just meant to provide additional notice to water users regarding existing rights that may be deemed abandoned. So there will be another public meeting following this, and then a final search for potential claimants by publishing a summons in the newspaper once a week for 5 consecutive weeks. Anyone who disagrees with the list of unclaimed rights have 90 days to file an objection and water users claim with the court. They must also file a water users claim with the state engineer. If there are any objections, once they're resolved, the court renders a decree on the LUR that identifies any rights to be removed, adjudges the unclaimed rights as abandoned, and finally prohibits future unknown claims from being asserted. So once all these claimants have filed their respective water users claims and the LUR has been decreed, then the state engineer will evaluate these claims and will map them and develop a proposed determination, or PD. So after the PD is filed with the court, individuals can disagree within 90 days, and then we will have a public meeting once again. And then once any objections, if any, are resolved, the court renders a decree on the proposed determination. So that was kind of a brief overview of the steps of the adjudication process, and I'm just going to walk through some of the main ones and some of the most important parts. So first, you may have heard me mention that we hold public meetings. These are held in the area, the subdivision of where this adjudication is taking place. And state law requires that the state engineer holds an initial public meeting in the local area to inform water users about the adjudication process. Next, I mentioned the crucial part of filing your water user's claim. These are mailed to water right owners and property owners and published in the newspaper, just so we can capture as many people as possible and get the word out to as many people as possible. So there are blank forms that are sent to property owners, and there are pre-filled out forms that are sent to water right owners of record. As I said, they have 90 days to complete and review and file their water users claim with the state engineer or the district court. And then they can request a 30-day extension only within those 90 days. And after this is complete, then we, the staff, will begin investigating these claims and mapping them. So here's an example of a water user's claim that's a blank form, and this is what property owners would get in the mail. This next form is a pre-filled out form. This is what individuals would get that are already owners of record or are using a water right with an owner of record. So we understand that it can be complex to define water rights, especially if you are receiving a blank form. It can be difficult to fill these out properly and know all of the aspects that define your water right. So adjudication staff can assist the individual in completing the claim. So when you file with the state engineer, they will file the claim with the court on behalf of the water user as a courtesy. The individual can, of course, file with the state engineer and the court if they would like to. So claims should be filed by anyone who owns a water right in the adjudication area. Even if the title is not in your name, if you use the water right, you should file. And here I was just going to mention that we have a map interface that you can find on our website. That's under the resources section and it's under the map search link. And it's essentially a way that you can visualize your map. You can scroll into the location where you live, or even input your water right number if you know that. And you can file a water user's claim on an area that is currently accepting water users' claims. And I believe that there will be another presentation that will talk more about this. So I mentioned the list of unclaimed rights, or the LUR. And this is just for water rights of record that have no claim filed within the 90-day period. These will be mailed out to all parties, so all individuals who got the other mail before will now get this one, and a public meeting will be held to explain the list of unclaimed rights. So claimants will have 90 days to file an objection, and they must also file their water user's claim, now with the court and the state engineer. And if the court allows the claim, the state engineer will evaluate the claim in the proposed determination, just like they would with the water user's claims that were received earlier. So once objections, if any, are resolved, the court renders a judgment that the rights on the LUR are abandoned, with the exception of those that are allowed as a result of the objection. They can also prohibit future diligence claims from being filed. So they're essentially preventing individuals who are stating, well, I have a claim, it's just not of record. You've been notified multiple times at this point, so it's assumed that there are no more diligence claims. So now we've gotten all these claims in, and as staff, we need to evaluate these claims. And essentially, the way this is done is that we have teams in adjudication, and these consist of engineering technicians. And they will conduct field reviews of the claims in an attempt to locate the points of diversion and investigate the details associated with the individual water right or groups of water rights. So if possible, the technicians will attempt to contact the water right owner and or claimant in order to set up a date and time to meet. So claim evaluation consists of reviewing the water user's claim that was submitted and the underlying documents on the water right file. Technicians will then visit the property and verify the uses with the owner and claimant. So they will typically take pictures, whether it's irrigation or domestic connections or any livestock that are on the property, and even the POD itself. And then they will confirm the location of the point of diversion using a GPS location. And then when they return from the field, they will use the images, any notes they took, the UTM location, and any relevant information from the file or talking with the owner, and construct a memo and an SER, or a state engineer's recommendation, and a map if necessary. So I mentioned that they will make a state engineer's recommendation. This is just how it sounds. It's a recommendation for the definition of the water right based on file and field reviews. So these recommendations can be essentially like this first one, where we went out and we saw, okay, they had 0.2 acres and a domestic. So we saw this, and we're going to print this out. This is our recommendation for the definition of this water right. We may have made sure that the point of diversion was correct. We may have made sure some of the other information was correct on the file. And then we will send this out via mail to the individual, whether it's the claimant or the owner, and we will put it on the water right file. This one is an example of a disallowed water right. So a water right may be disallowed based on evidence of non-use, so forfeiture, or a claim may be disallowed due to its invalidity, so it has no legal basis. So an example of non-use would be essentially they haven't used it in 7 years. And that's essentially it. And a claim may be disallowed to being invalid, so that would be an example of an individual who was filing a water user's claim and they didn't know that they were really on city water. That's invalid. They don't really have a water right. So as I said, a memo that the staff will write about what they did, why they chose to make the decisions that they made, and the SCR and a map will be mailed to the claimant and or owner. So I mentioned the map. These are the hydrographic survey maps, and this identifies the location of the POD and any irrigation or ponds. And this not only helps in determining the water rights, but also is essentially a historical snapshot in time, which could be helpful for the future for research purposes. These can be found in hard copies at the regional office or at the Salt Lake City office, and they can also be viewed online on our website. So once we have finished the hydrographic survey map, the state engineer's recommendations have been finalized, then the proposed determination is published. And it's distributed to water users and filed with the district court. The proposed determination represents the state engineer's official recommendation of rights within an adjudication boundary. And then a public meeting will be held to discuss the proposed determination and answer some questions that the water users might have. Each book, as you can see on here, this is what we call a book, has a unique name and number. So the name typically incorporates some sort of aspect of the subdivision. So on this example, it's Tooele Valley and Tooele City. And then the number is the area number, which corresponds to the various drainage numbers that are used by the state engineer's office. Then it's followed by a book number, which is just to further divide the area. So in the early days of adjudication, one proposed determination was published for one river drainage. So examples of this would be the Weber and Sevier rivers. However, Utah has increased in population and natural resource development, and therefore the number of water rights have increased. Beyond the ability of adjudication staff to just tackle an entire basin at a time. So this is why, as I mentioned, the divisions and subdivisions. So if you look at the Utah Lake Jordan River drainage basin that's right in the middle of Utah, there are a lot of divisions and subdivisions in there, and that just makes it easier for our staff to go in there and tackle these individual areas. So, and because of this, in parallel with the proposed determination, when you prepare it for smaller geographical areas within the larger drainage, we will petition the court for an interlocutory decree or a partial decree. And these are just issued for the subdivisions of the river drainage. So an interlocutory decree is basically a transitional decree. It's used to settle the issues of a particular book. And once all subdivisions have an interlocutory decree, the court is petitioned to issue a decree on the entire drainage. So federal reserved rights are often admitted from these interlocutory decrees, but their water rights will be recognized in the proposed determination. So once an entire drainage has an interlocutory decrees, the federal government is then joined in as a party, just like any other water user, and then they're formally adjudicated. And here is where we have federal joinder, where we've joined in the federal government. So when a court issues an interlocutory decree, it will often include language that essentially says it's closing the respective basin from any additional diligence claims. So before I get into these frequently asked questions, I have one that's not up there. And a common question that we get when we start a new area or when we have these public meetings is whether or not a water user will lose their water right. The state engineer does not have the authority to take water away. We can only recommend to the court that a water right be disallowed on the proposed determination. So ultimately, individuals who are using their water right according to the records really have no reason to worry. So moving on to these questions, what happens if a water right user chooses not to participate in a general adjudication? So if they choose not to participate, any rights not claimed may be declared abandoned, and they may lose their right to appeal or object to the proposed determination. What should I do if my water right is listed in the name of a previous owner? I mentioned this really briefly earlier. The title updating process is completely separate from adjudication, but you should file a claim as a claimant to protect the water right from being declared abandoned. It's not abandoned, you're currently using it. You just need to update title. So later, update the title to the water right. And last, grand juries are not part of the adjudication process. So these are some individuals you can contact to discuss the adjudication process. First is Mike Drake, and then there's Gary Brimley, my boss, and the front desk for the adjudication program. Are there any questions?
I don't see anything in the chat. Does anybody have any questions for Megan? Okay, thank you, Megan. We appreciate you being here with us.
You're so welcome. You guys have a good day.